Jury instructions and jury interrogatories. Jury instructions. At the end of the case, that is, at the end of the case when all of the testimony has been in, there will usually be a hearing outside the presence of the jury where before the attorneys give their closing arguments, there are requests for jury instructions submitted to the court, and the court will tell you what instructions they're going to give the jury. The jury instructions, and we've used them briefly in preparing complaints. And basically, jury instructions are the law. They will explain to jurors that they are the final determiners of the facts that they believe, and they will explain what the law is in a particular area. So the judge does that. And I can tell you that I've been in courtrooms where the jury instructions have taken sometimes a couple hours. I don't know how jurors follow them, quite honestly, sometimes. But in any event, the judge gives those instructions, and it's the last thing that jurors will hear before they go back to determine what the verdict is going to be. It helps us understand that jurors are going to listen to all the testimony of the witnesses and decide who they're going to believe out of the stories that they've heard, and then they're going to apply the law as the judge has told them to apply it. And it's a very important part of the case. Many people will tell you that studies all show that of all of the people in the courtroom, the judge is almost always the most influential. The judge will also tell the jurors that the judge's opinion about who to believe is not significant whatsoever. The jurors are the ones to decide who they believe. But they are supposed to apply the law as the judge explains it to them. So, for instance, with respect to, say, a fight, in cases you'll find that there are always two stories, the plaintiff's story and the defendant's story. So, and they'll often be entirely different. The plaintiff will say they were home in their house minding their own business, and the defendant burst in and struck them. The defendant will say, no, I was walking along the street and the plaintiff ran out and hit me. Well, you have two different stories, and what the court will do is explain what the law of self-defense is. Briefly, an aggressor can't contend self-defense, so you can't start a fight and then say, oh, I was defending myself. Certain rules provide more protections, legal protections, if you're in your own home using self-defense. So the judge would explain those things, and then the jury would go back and decide who they believed. In other words, where did this fight start, who was the aggressor, and then we'll apply the law as has been given to them. It's a critical portion of the case. The arguments between counsel and the court are often very heated about which jury instruction to apply, and it's crucial. Oftentimes, appeals are focused on the instructions that the judge decides to give, because if the judge decides to give an instruction that the other side feels was favorable to the bad guys, that will oftentimes be a matter of appeal, where you'll be arguing that the law would require having given a different instruction. So that's crucial. I did mention jury interrogatories because I think that it's a little something that you ought to know. And if you're thinking, wait a minute, didn't we talk about interrogatories when we mentioned discovery? Yes, we did. These are questions, but they're not the same as discovery questions. Think about this, everybody. If you had a case involving 5 counts, let's say one count was something intentional that someone did, and if a second count was something unintentional, you'd want the jury to come back and tell you that the jury finds that the defendant's actions were either intentional or unintentional, so you'd know that. oftentimes that has significance because some types of insurance will not pay if someone did something intentionally. If something's done unintentionally, then insurance will often pay. Let me give you a simple example to try and make sense out of this. If you got into a tussle with your neighbor and were sued by your neighbor, if it was, say, in the nature of a fight, if the court determines you intentionally did something to injure your neighbor, your homeowner's insurance may not pay for that. If it was done unintentionally, your homeowner's insurance may very well pay for that. So that's why you'd want those interrogatories from the jury. Let me give you another example, if I may, and it's not exactly in civil litigation, but I think it's a good example in death penalty cases. Death penalty cases often turn on whether there were mitigating factors or aggravating factors. Is there something good about the person who's been convicted that the jury considers believable? If there's something aggravating. Aggravating factors in a homicide case would be if someone killed someone for money. So that what we want the jury to do is tell us that based upon the evidence, they believe that this was an aggravating factor, and they'll list what those were. That may decide whether or not the person is given a death penalty or not. So jury interrogatories are important. They're a series of questions that the jurors will take with them into the jury room. When they reach their verdict, they'll check off each of the ones that they believed were appropriate to